Part 8 of IBC Amendment Act 2026. Now we are discussing on the secured creditors, distribution, waterfall and dissolution. Detailed FAQ format. What are the major amendments relating to the secured creditors under IBC Amendment Act 2026? The IBC Amendment Act 2026 introduces significant reforms regarding the rights and obligations of secured creditors during liquidation. The objective is to ensure transparency, coordinated enforcement of security interest, and equitable distribution among the stakeholders. The major amendments include the mandatory identification of security interest within a specified period and deemed relinquishment of security interest in case of non-compliance, and approval mechanism where multiple secured creditors have security over the same asset, and mandatory contribution towards insolvency and liquidation costs, and clarification of the waterfall mechanism under section 53, revised provisions relating to government use, time-bound dissolution process. So these amendments aim to improve a recovery while ensuring fairness among all creditors. What changes have been made to section 52 regarding realization of security interest? Section 52 allows a secured creditor to either relinquish its security interest to the liquidation estate or realize it independently. The amendment introduces an important requirement. A secured creditor intending to realize its security interest independently must inform the liquidator, identify the secured asset, complete this exercise within 14 days from the liquidation commencement date. Failure to comply results in security interest being deemed to have been relinquished to the liquidation estate. So this amendment prevents uncertainty and delays in liquidation process. So what happens if there are multiple secured creditors over the same asset? The amendment introduces a new coordination mechanism where more than one secured creditor has a security interest over the same asset. No secured creditor can independently realize its security unless creditors representing at least 66% of the value of all secured claims agree to such realization. Purpose of the amendment: this provision aims to prevent conflicting of enforcement actions, protect the value of the secured asset, ensures coordinated realization, and reduce litigation among the secured creditors. This is expected to make liquidation proceedings smoother and more efficient. Are secured creditors required to contribute towards insolvency and liquidation cost? Answer is yes. The amendment modifies section 52 subsection 8 to ensure that secured creditors who realize their security interest independently contribute towards insolvency resolution process cost, liquidation cost, and workman dues as specified under section 53. So the secured creditor must transfer the applicable amount to the liquidator in the manner and within the period specified regulations. This ensures that all the stakeholders shares the costs of the insolvency process fairly. So what clarifications has been made regarding the secured creditors under section 53? This amendment inserts an important explanation to section 53 where the value of the security interest relinquished is less than the total debt owed to the secured creditor, then the creditor shall be treated as a secured creditor only to the extent of the value of the security interest. The remaining unpaid debt shall be ranked as the unsecured claim under the waterfall mechanism. I'll give you an example. Outstanding debt, suppose 100 crores, security 70 crores. Then the remain secured, the creditor is the secured for 70 CR, becomes unsecured for remaining 30 CR. So this amendment provides statutory clarity regarding distribution. So what clarification has been provided regarding the government dues? Amendment introduced the detailed explanation regarding the government dues. Amount payable to central government, amount payable to state government for the 2 years preceding the liquidation commencement date shall be distributed under the priority specified under section 53. Any remaining government dues beyond the period shall rank lower in the waterfall. Here, importantly, the amendment clarifies that this treatment applies whether or not a statutory security interest exists by operation of law, whether it is there or not. So, the amendment clarifies that this treatment applies whether even or not a statutory security interest exists by operation of law. Then this removes ambiguity regarding the priority of the statutory dues during the liquidation. So no confuse, no ambiguity. What illustrations have been inserted in section 53? If you see, the amendment insert 2 statutory illustrations to clarify the operation of the waterfall mechanism. Illustration number 1, where a contract provides that secured creditors will be paid before workmen. Such contractual arrangement shall be ignored because statutory priority under section 53 prevails. Another illustration, contractual arrangements between secured creditors determining priority among themselves will continue to be respected. So these illustrations help stakeholders understand the distinction between the statutory priorities and the inter-creditor arrangements. What amendments have been made to section 54 relating to the dissolution? Section 54 has been substantially amended to make dissolution time-bound. The liquidator must complete the liquidation, file an application for dissolution within 180 days from the date of liquidation commencement date. The adjudicating authority may extend the period up to 90 additional days upon sufficient cause being shown. So this amendment seeks to avoid prolonged litigation proceedings. So then what happens if the avoidance proceedings are pending at the time of dissolution? The amendment specifically provides that where the proceedings relating to the avoidance transactions, fraudulent trading or wrongful trading or application under section 47 remain pending, the committee of creditors shall determine how these proceedings should continue, how any future recovery should be distributed. Importantly, dissolution of the corporate debtor does not automatically terminate such proceedings. So this ensures that the persons responsible for wrongful conduct cannot escape their liability because the company has been dissolved. Can a company be dissolved even if some assets remain? Answer is yes. This amendment introduces the section 54 subsection 2a, which empowers the adjudicating authority to dissolve the corporate debtor even if certain assets remain. In such cases, the remaining assets shall be disposed of in the prescribed manner. Insolvency resolution process cost shall first be paid. Any surplus thereafter shall be credited to the Insolvency and Bankruptcy Fund constituted under the IBC code. So this prevents unnecessary delay in dissolution due to the residual assets. Does the dissolution affect the pending legal proceedings? Answer is no. This amendment clearly states that the dissolution does not affect the continuation of proceedings relating to the avoidant transactions, wrongful trading, fraudulent trading, and even distribution of recoveries arising from the such proceedings. So this ensures that the wrongdoers remain accountable and creditors continue to benefit from successful recoveries even after dissolution. How will these amendments benefit stakeholders? For financial creditors, greater certainty regarding the enforcement of the security, for distribution of proceeds and reduced disputes, even for secured creditors, clear timelines, defined rights, and better coordination among the multiple lenders. For liquidator, better guidance for asset realization, clear timelines for dissolution, improved administration of liquidation. Even for government authorities, clarity regarding the priority of the government use, reduced litigation. Even for COC, continued oversight over pending proceedings, better control over recoveries. So the key takeaways is amendment relating to sections 52, 53 and 54. Strengthen the liquidation framework. Mandatory declaration of security interest within 14 days and deemed relinquishment for non-compliance. And then the third one, 66% approval requirement where the multiple security creditors exist on the same asset. Mandatory contribution towards the insolvency and liquidation cost. Fifth one, clarification regarding secured and unsecured portion of the debt. And sixth one, greater certainty regarding the government use. And seventh one, the statutory illustrations explaining the waterfall mechanism. Eighth one, the time-bound dissolution proceedings after time-bound dissolution. And ninth one, contribution of avoidance proceedings after dissolution. And 10th one, simplify disposal of residual assets. So these reforms are expected to improve recoveries and reduce litigation and make liquidation faster and more transparent. We have two channels, RR Corporates, other channel RR Legal Talks. Please do subscribe, hit the bell icon so that you will not miss my latest videos. We'll meet in next part 9. Thank you.